a lifeline.
And you don't seem to
A phone is a
appreciate it.
lifeline.
I'm the one that's been paying
No,
for it.
Robert's on a podcast. Told me
No, he
you-
didn't buy it. He didn't buy it. No, he did not, Trace.
He told me he did buy it.
No, he did not.
Who, you bought it?
I'll explain to you. Good evening and welcome. Who am I talking to?
We spoke I think it was yesterday or the day before.
Who is this?
Daughter,
who is this?
With the appendix.
Right.
Remember?
Hold on one second here because I'm getting ready to start I'm already live and people are hearing me talking. So let me welcome everybody here and hold on a second.
Okay, no problem.
Yeah. Good evening and welcome. Sorry for the rocky intro. I had a CPS case that wanted to talk to me tonight. Her name it's a couple, and they had false accusations by the social worker medically neglecting their 4-year-old daughter, who's now 5. And the 4-year-old daughter was misdiagnosed having appendix, and they took out the appendix by mistake, found out that she had gallbladder stones, and that was a real culprit. It was really very sad to hear all that. And I'm going to get to them in just a second. I just wanted to wish everybody here a warm welcome. And you've reached the Fight CPS Stop Taking Our Children. I'm your host, Bob Pace. Now, I'm on here twice a day. In the morning, I'm on Monday through Friday at 10 a.m. And on the weekends, I'm on at 7 p.m. Excuse me, on the weekends, I'm on at 8 a.m. So Monday through Friday from 10 a.m. and then Saturday, Sunday at 8 a.m. Then the evenings, I'm on at 7 o'clock. 7 o'clock. And I'm sorry, there's distraction here. I broadcast this from home and I don't really have any privacy here. Anyway, let me go ahead and introduce our guest and get her talking. She's been waiting already. So go ahead and introduce yourself and your husband, and then, you can briefly tell me where you're at on your case.
Hi, my name is Jessica, and my husband's name is Pyro.
Okay.
The last time we spoke to you, you gave us amazing advice of asking for continuance, 60 to 90 days. And we have our case tomorrow at 8 in the morning. And we didn't have an attorney until this evening. But when I spoke to my attorney and I explained to her what I wanted to do, which was ask for continuance for our case so we could have more time to discuss evidence that we have collected, character letters or character reference letters from people, and a bunch of other evidence that we want to submit for a motion to dismiss. The attorney told me that because it's the initial hearing, we had to say that we acknowledge the paperwork that the caseworker submitted to the court, and then we'll have to wait until our next hearing. In our next hearing, we would submit a general denial, and then after that, and that's how it would go. But I told her I wanted the initial hearing to request a continuance, and she refused. So now,
well, then you'd say you should tell her I need a new attorney. I need an attorney that's going to fight for me. The problem is she's trying to railroad you. You don't admit that you received any paperwork or anything else. You don't want to admit any of that in court. You don't want to go to court because it is not right, and you want to ask for a continuance. Now, were you able? Was Pyro able to talk to Mr. Davis?
We were talking to him a little bit ago to see if he can give us a discount. He said his discount right now is 50% off for $150. So we were trying to ask him if we could do another deal, because when we did the $300, we didn't have our court documents yet.
Right,
so
but there was
we're
also
still in the process
one
of
that you could. there's one that's coming up that's for free for 15 minutes, and then there's a 30-minute one for $60. What about the 30-minute one for $6? You go to that website?
We're gonna do that after the call with you. We just wanted to make sure we didn't miss your live.
Well, I understand, but I'm really worried about the time frame because right now I doubt very seriously Mr. Davis can meet with you that short of a notice. When you talked to me on Sunday, I was hoping that you could call the office on Monday. They were not closed, by the way. They were open on Memorial Day weekend. And I was hoping that you could call them or not call them, schedule that time and see if an opening's open on Tuesday and see them today. What this court-appointed attorney does, she's buffaloing you. What's this thing she's saying? What is this thing she says you have to admit? What do you have to admit to?
That's what I was telling her. I told her that this shouldn't even be open, that there is a lot of errors and misinformation on the court documents. That's why I want to request a continuance. And she said standard procedure is to acknowledge the claim and then submit a general denial. And I said, but I don't want to acknowledge anything. And then so she said, according to WIC section 33332 or 330, I forgot which one she said, that if I ask for continuance, they will only give me 1 day. And then I told her, but there is also a subsection where it says that you can request a longer period of time if it's something as important as wanting to submit a motion to dismiss. And she basically denied that that was even possible.
Well, no, it's not the motion to dismiss. That's not what the continuance for. The continuance is to have time to speak to an attorney about your case. That's what the important thing is.
I also mentioned that to her. Yes.
Was she rude? Was she rude to you? Was she rude to you?
She was really rude to me. Yes.
That's what I thought. You should have also asked her, why are you talking to me so rude? You're supposed to represent me. And secondly, if you can't do what I'm asking, then I have to call the state bar tomorrow and report you that you are.
Oh, I can do that?
Yes, you can. You can do a complaint. That's what you could have done today. This attorney isn't going to help you. They're going to try to railroad you in. It's ridiculous. You parents are being taken advantage of, and you need a real attorney.
Yes. She did say that she's going to be there tomorrow morning and going to tell the bailiff and the judge that I want to speak to, go to the bench. So she's basically telling me that I'm going to have to ask the judge myself for continuance.
Well, yeah, just say you got the attorney late last night and you need some preparation time for this first hearing. Okay, what is the hearing? Okay. Let's look up, like I did with appendicitis and gallstones. Let's look up, let me see here. Santa Clarita.
The court is in
hold on. I can't hold on. Santa Clarita, California, CPS. Now, what is this first hearing called?
The initial hearing. That's what they call it, the initial hearing.
I'm typing it in. I think it's called the detention hearing, right?
Yes, the detention hearing.
Okay, this is what it says. The hearing process follows CPS investigations can be long and complex. Here is everything you need to know about each and every step in the process. The detention hearing. When the emergency response social worker does find a child to be in imminent danger in the home, the law permits the CPS agency and law enforcement to immediately remove the child. They did not remove the child from you, right?
No.
And place them in protective custody for up to 72 hours. So we don't have to worry about that. A petition alleging child abuse or neglect must be filed within 2 days of removal. So I don't know what they're going to file. A detention hearing must be held no later than the end of the next court day after the petition is filed. So I don't even know what they've filed. At the detention hearing, the court will determine whether the child should be released in the parent's custody or remain detained pending court hearing on the allegations in the petition. The child must be released unless the court finds the court has made a prima facie showing of the risk of harm sufficient to justify the child's continued detention. As the parent or guardian, you're entitled to present all relative evidence and call any witnesses necessary to rebut the county's case. You have the right to cross-examine any witnesses against you. This is before you use an attorney. If you use that court-appointed attorney, that will kill you because you can't longer talk in court. While entitled to a court-appointed attorney, parents are strongly advised to retain independent counsel. Burdened with overwhelming caseloads, hold on 1 second.
Yes, no problem.
Hold on. Okay, I'm back. I'm sorry, I'm back. As you know, I do my show out of my house. And so I have family around. Sometimes they come in at the least a moment time here. But go ahead and tell me, we're talking about the dependency hearing.
Yes.
Now, it says, while entitled to a court-appointed attorneys, parents are strongly advised to obtain independent counsel. Burdened with overwhelming caseloads, court-appointed attorneys have little time to spend on individual cases. Where the custody of your child is at stake, you need effective representation of a well-prepared advocate, thoroughly informed on the specifics of your case.
Yes, the attorney says she has 100 cases at the moment.
Yeah, exactly. Parents and guardians are entitled to a trial on all allegations of child abuse or neglect charged against them in the petition, known as a jurisdictional hearing. Now, that's the next hearing. Parents can invoke the right to have this trial held within 15 court days of detention hearing if the child is detained, or within 30 days of the date the petition was filed if the child remains in the home. Now, at the jurisdictional hearing, the court will make an actual finding as well to whether the child has suffered abuse or neglect as alleged in the petition. If the court determines that the county has proven the truth of the allegations by a predominance of evidence and that such allegations are legally sufficient to justify state intervention, the court will sustain the petition and declare jurisdictional the child. They have to be a preponderance of evidence. Now, what I'm asking you is, I was asking you, will your pediatrician, do you have that letter from him stating that?
I do.
Okay. And do you have a letter from the first hospital? Go ahead.
So I have the letter of the pediatrician, and it says that in her medical and professional opinion, we are diligent parents who always take her to her appointments and always bring her when she's sick to make sure she's well taken care of. So she doesn't see at any point that we were endangering her medically. And then we also have the first document of the ER we took her to, which states that she was not in imminent danger. And then the second document of the ER that we went to children, on those documents it also states there when they were doing her observations that she was not in imminent danger and she was and her life was not at risk. There's questions there that they put no to, even though what they're saying is contrary or what they had said.
What were the questions they wrote no? What was the questions they wrote no to?
Yeah, the questions are, does the child seem to be in imminent danger? They put no.
Okay.
So I have those documents with me that I wanted to discuss with my attorney, and that's what I told her, that I wanted to do a continuance so we can have time to properly prepare documentation of all the errors that were claimed on the court documents that they currently have.
Okay. Okay. So we're going to the detention hearing. Is that what the paperwork says, detention hearing? What does the paperwork you have in your hand say? What does it say?
Hold on. Let me see. Because right now we're printing out everything for tomorrow. So I don't have, let me see if I have it here. 1 second. Okay, yeah, I don't have it at the top of my hand right now.
Okay. Do you remember anything about it?
It's for welfare and institutions, section 300. Is what the court case document said that I remember.
Okay.
And it was failure to, it said failure to adequately protect my daughter.
Okay. You say again, the section, what was again? What section?
Section 300.
300, go on.
Section 300, on the title of on the front page, it says they marked section 300. There's like 3 options, and they marked that one off. And then on the back of the page, it said 300, and the additional checkoff was for failure to adequately protect child.
Adequate. After the section code 300, is it A? Is it B?
It's A. It's the
Okay.
first one.
The child has suffered, or there is substantial risk the child will suffer serious physical harm inflicted non-accidentally upon the child by the child's parent or guardian. So they say that you're going to inflict or have inflict and on purpose against the child. For the purpose of subdivision, a court may find there is a substantial risk of serious future injury based on the manner in which a less serious injury was inflicted. A history of repeated inflictions of injuries on the child or the child's siblings, or a combination of these and other actions by the parents or guardians that indicate the child is at risk of serious physical harm. For the purpose of subdivision, serious physical harm does not include reasonable and age-appropriate spanking to the buttocks if there's no evidence of serious physical injury. So that's what that is all about, really, is the physical harm. And I don't, your track record shows fine. You went and saw your pediatrician. Then from pediatrician, you saw the emergency room. When did they diagnostic that she had appendicitis?
The first emergency room.
All right. Now, is that in their paperwork? Is that in their paperwork they released to you?
Yes. On the medical record.
Okay.
That I have.
And what did they say about you commenting on that? Was there any comments about you in that paperwork?
In the first ERs, yes, they said that
the parents wanted a second opinion, correct?
Yes, and that they said that it was fine. She looked like we were basically. I'm paraphrasing, but in the first ER, they said that they have copies of the conversation they had with the bioethics committee, and that they stated in there she was not in imminent danger, and it was okay and in our right to take a second opinion.
All right. So when you went and got the second opinion, they're the ones that went ahead and did the appendicitis.
Yes, the surgery.
Now, were you agreeing to that, or you just went along with their diagnostic?
No, we didn't agree to that. We wanted to. We didn't want surgery. We had agreed with them to keep her on antibiotics and observation for 3 to 4 days, and at the second day, they were pressuring us to do surgery, bringing in 8 different doctors at the same time while my husband was there with my daughter, and we were not denying treatment. We were just denying surgery. That's why we took her out, because they kept wanting to do surgery, and we had already agreed antibiotics over monitoring. And then when we took her out, because of the pressure they were giving us, that's when they sent the social worker and the sheriff.
Okay. And if you took her out, why did they do the surgery?
Because when the social worker came to our house, she told us to come back, and we weren't able to do any other treatments or monitor her. So when we brought her back, I think like midnight, they did another exam, and they said that now that there is a little bit of perforation on her appendix, just like a small leak on her appendix. And they said that they were going to do antibiotics and monitoring, but I told them, why would you do that? If you're telling me it's perforated, then we would need surgery, because if it's leaking, then that's when it's dangerous. So I told them that because of what they were showing me, we should do the surgery. But then after the post-operation, we took her again. It was obstruction of the small intestine. She was in there admitted again. We took her out, discharged. She was discharged. And then after that, she still had the symptoms. We brought her back, and then they found out she had gallbladder stone. Okay, the people that fall into gallbladder stone, do you have paperwork from them? Yes, I have all the medical records.
Okay.
Printed.
Okay.
And copies for each of the attorneys.
Oh, okay. Do you got one for the court for the judge?
I have one for the judge, one for my attorney, one for my husband's attorney, and 2 for my both husband's attorneys.
Okay. All right. Do you have one for the child's attorney?
Yes, I have 5 copies. How many do I need? 2 for. I think I need one more copy.
Well, also you need one for the social worker too.
Oh, really? She came to our house today, actually, to check on both of our kids, and she said she wasn't going to go to the court, and she has nothing to do with that.
Well, I can't trust her because she'll be in court. And
I knew it. She told me we were never going to see her again before that. And then now she's telling us that she's going to be coming every month. So, yes, I know she's a liar, so I'll print out one for her as well.
yeah, well, the problem being is that, did you mention this all to her and she's still convinced that you were endangering your child by refusing?
She's telling us that she has nothing to do with the court case.
Well, she's the one that wrote the report she's the one that made the allegations.
That's what we told her. She said it's not her fault. That she has nothing to do with that. That's what she was telling us.
She's the one that made the allegations, right?
Her name is there too, and we told her, but she's denying it.
Hmm.
It's a very weird situation with that woman.
Wow. Well, you're still going to show up tomorrow. You're still going to try to do your best. You're still going to ask for a continuance. You have your right to it, but do not sign anything or accept anything that's thrown your way.
Okay.
I mean, what are they asking you to sign? What promissory note are they asking you to sign?
They're not asking me to sign anything right now.
Oh, I thought you said they were trying to.
No.
Okay. Let me say hello to my people in the room. I don't want to ignore them. They've been part of my room for the last 19 months. And so I need to tell hello to them. Hold on a second, okay?
Yeah, no problem.
I want to say good evening to Lexington, Kentucky, to the Brown Rescue. And she talked to me this morning. I'm glad to hear from her. She says, hi, Jessica. Prayers for the best possible outcome. And Christina Renoza is from Texas. And so she says, have her text in him anyway. Christina Rose says, have her go to Vincent Davis like at 6:30 tomorrow morning. Yeah, you could do that at 6:30 tomorrow morning. He has a show he does at 6:30 in the morning, and you could probably call in.
Okay, I'll do that.
Yeah, I'm just trying to help you. Dorothy Cook says, I'm sorry, my Zoom and phone will not work properly tonight for my 9:30 Zoom meeting, but thank you. Okay, that's from Dorothy Cook from North Carolina. Dorothy Cook did say that her attorney has 100 cases at the time as a court-appointed counsel. So not only do you have, your attorney has 100 cases, Dorothy Cook's attorney has 100 cases. And Intended Eve, welcome. I have no idea where you're from, Intended Eve. Above it should say the type of hearing. I agree. And then thanks for God for each and every blessing. Okay, thank you. I have no idea what your name is. We're here in a CPS environment. Please state your name, the city, the state, and a little bit about your case there. Now, they're saying, is the serving to the social worker supposed to be hand-delivered or certified mail? Signature to guarantee proof point. At this time of night, they got court tomorrow morning. What time is your court tomorrow morning?
It's at 8
Okay,
uh-huh.
They got a court at 8 a.m. in Monterey Park. That's where the CPS uses the court. They're going to go to what's called dependency court. And they're going to speak before a judge who probably knows nothing about their case. And they're going to try to say that she's endangered her children, and that's why they have charges against her. And they're probably going to sit there, they want to take your child. And it all depends on how this attorney you're using there. Right now, it's too late to call the state bar tomorrow morning at 8 o'clock to call on that attorney. And you just got to tell them, when you're talking to the attorney, with all due respect, ma'am, you have to defend me. I know you may have 100 cases, but my case is just as important. And these are fraudulent charges. And I depend on you to take care of my family and defend me. So at 6:30, try to get on Vincent Davis's live stream and make a phone call. Okay?
Yes.
When you hang up with me, call the office and ask them what time Vincent Davis is on and how to watch him. Okay?
Okay.
You call that number.
Where can I find the phone number for their office?
888-888-6582. It's on my screen.
Okay. Got it. Okay, Mr. Bob, I'll call them right now so you can have a chance with another caller.
Well, I will,
You
but
are
I'm
very
just really,
knowledgeable.
I think you have a really strong case. It's just how it's going to be played right. So just go over one more time. Who said what? Okay, first of all, the CPS of LA County sent you this hearing to be at. And it's a deposition hearing where they're going to try to decide where your child's going to be.
Yes.
Now your child's with you. Your child has been treated. How is she doing, Jessica? How is your daughter doing?
She's doing very good.
Okay, good.
She did
Good.
8 pounds in the hospital when she was on antibiotics and fasting.
Okay.
So we're trying to get her to eat. Yesterday and today were the first days that she's not having pain with food. But we're having her on a strict diet because certain foods with the gallbladder stones can get really irritated.
Right.
But she's doing
Now, are the gallbladder stones been removed, or are they trying to dissolve them?
So when they found the gallbladder stones, they didn't state on the medical records nor tell me of any future treatments. They said they're small enough to dissolve on their own.
Okay, but that's on the reports.
That's on the report.
Okay.
But there's no treatment mention
Right.
of treatment or anything.
Okay. Well, you can still approach the judge and ask for a continuance because you tell them you're not prepared because you just got an attorney late last night, and that attorney has 100 cases, so she needs some time to digest your case
Okay.
to this first hearing. Now, this first hearing, let me take a look at it again. This is called the detention hearing. And that's usually where they determine where the child will be. Will it remain with the parents or will they take the child out? If the child is comfortable and they've done that surgery and everything, don't mention the malpractice lawsuit on the appendicitis. That's a separate issue that shouldn't be brought up in this court here. Just mention that you've done everything that the doctors have told you. You wanted a second opinion. You have every right to ask for a second opinion. And they removed the appendice, but that didn't solve the problem. To make a long story short, she still had the similar pains. Upon them doing an x-ray, they found gallstones, and they're blocking the ductwork. And that is bile that's hardened up in there that helps dissolve food and stuff. And they are now recommending to dissolve the gallstones and pass out of her uterine tract. Okay. Is there anything else you have, or Pyron wants to ask me anything?
No, that's everything.
Okay. Is there anything that you forgot to tell me, or anything that you need to know or understand?
So when we do the continuance, and they give us the 30 to 60 days, and my attorney is still not having the best interest, I have to call the bar and request a new one?
Well, no. You call the state bar to register a formal complaint that the attorney is not performing her job. You go to, at Monterey Park, there's a court there. You go to the public defender's office and ask for a new public defender that doesn't have 100 cases. But meanwhile, you should try actively to get Vincent Davis to help you.
Yes. Yes, that is our main goal, and we're trying to see if we could.
Well, I'm confused.
raise
What's
funds.
this about the rate thing he was trying to? I don't understand. What was he trying to do with you?
So initially, we paid $300 for a 30-minute, right? And we didn't have our documents, but my husband stayed talking to him about other matters since we couldn't talk about that case. And today we we saw that on his social media he has 50% off, so $150 for 30 minutes. And basically we asked if, since we didn't have the documents, the first conversation, if he was willing to put the discount 50% to the original meeting, and the $150 left over if we could do a 30-minute call tonight. But he said that the previous call there was no deal at that time, so $300 is not going to roll over to the other one. So that's where we left off in our conversation.
Well, what about that website I told you to go to a couple days ago for that 30 minutes for $60?
Yes, for that one, I told my husband about it. I don't remember what my husband said, but I told him to remind Mr. Vince about that $60 as well. So
Well, you don't understand. It's a special deal that I made. He has to honor it.
Okay.
It's a deal that Bob Pace made. Let me put it up on the screen so you can see it, okay?
Okay.
Hold on a second here.
Okay.
Okay. Okay. Okay. For $60, you can get a 30-minute Zoom consultation with Attorney Davis, care of Bob Pace. Here's what you need to do. You go to https://www.candely.com/apps/VWD/Bob Pace. Do you see it?
Yes, I do. I see it.
Okay.
I took a picture right now.
All right. So now that is your $60 for 30 minutes. You can do 1 hour for $500, or that other discount rate for $150 for 60 minutes, right? That just, you got another one in there. And plus
Right.
you're going to get one, and within the week of talk to them for free for 15 minutes. Now, at any time, do you have the funds to maybe hire him? Or you?
We're actually in the process of collecting them, so like doing asking everybody we know for donations.
Okay. Because if they give you a continuance, they'll give you more time for that. If they don't give you a continuance, the next thing they got to do is they have to have the jurisdiction hearing.
Okay.
The detention hearing is the first one they're going to do there, but then there's, excuse me, I'm saying it wrong. There's the detention hearing, then there's the deposition hearing. That's the next hearing.
Disposition hearing.
Yes, and then there's status reviews.
Then status review. Okay.
Okay. When a petition is sustained at the jurisdiction level, the next phase is a deposition hearing. So if they're able to prove at the jurisdiction level, the hearing is usually conducted on the same day and immediately following the jurisdiction hearing, though it may be continued for up to 10 days if the child remains detained pending the hearing, and up to 30 days the child remains in the home. At the deposition hearing, the court determines whether or not to declare the child a dependent. If the child is adjudicated a dependent, the court then addresses the issues of the child placement and reunification services. The CPS worker will submit a case plan outlining the necessary actions a parent must take to resolve the problems that warrant CPS court intervention. See, that's where they're going to ask you to take parenting classes, program classes, sort of like that. The case plan will include a list of services requiring the parent's active participation and must be specifically tailored to the needs of the family in order to promote successful reunification. Through the jurisdiction has already been declared over your child, it's within the deposition court discretion to set aside jurisdiction hearing findings. Therefore, the court may still dismiss the government's petition or order informally CPS supervision without declaring a dependency. If the court asserts jurisdiction, declares your child a dependent, a ruling must then be made on whether your child may remain in the home while you engage in unification services, or if outside placement is necessary until progress is made in accordance with the case plan. The court must return the child to the custody of the parents or guardians unless the county presents clear and convincing evidence that returning will create a substantial risk of detriment to the safety, protection, or physical emotional well-being of the child. When an outside placement is ordered, the child must be released into the custody of the non-custodial parents unless there is clear and convincing evidence that such placement would be detrimental to the child's welfare. If released to the non-custodial parent is not an option, preferred considerations for placement are given to certain relatives' request, and to non-relative extended family members will also be considered before placing child into foster care. See, they're trying to do it with next of kinship and everything there.
Yes.
But I'm telling you, you and your husband need to go on the internet and research. Put in the city, the state, CPS, and then put in all the different questions you have.
Okay.
All right?
Okay, we'll do that.
All right. Well, thank you again.
Bob. Thank
You
so
bet.
much.
And keep in touch. I'll be on tomorrow morning.
Yeah.
So keep in touch. I want to know the outcome.
Okay, yes, we'll definitely let you know.
Yeah. Okay, I'm back
Thank
to
you so much.
okay, thank you for calling. Then
Bye.
okay. That was Jessica, who has a bad, I don't know how they're able to justify what they're doing to them. They have the documents supporting that they did nothing wrong with getting their child treated. They followed every good common sense parents would. Every good thing. Now, I left off with Dorothy Cook saying some things. Let me see if I can catch up here. Dorothy says that page is mine, Dorothy Cook. Thanks to God for each and every blessing from North Carolina. What page is yours, Dorothy? I'm confused. Is someone, can CPS courses be video recorded? If so, how? I don't know, because you're not in a public area. So they could restrict you from recording it. You can certainly ask them. Can they have a detention hearing without a parent being served or in attendance? No, they have to have the parents present. If they do that, that's illegal. There's a lot of things that break your constitutional rights, your civil rights. Now, I'm going to put my phone number up. If anybody else would like to call in. Oh dear, they now have eliminated my message for my phone number. All right, I'll create a new phone number here. Okay, there's my phone number. It was somehow erased, and so now I have it back. I share this room, and so it may have been taken there. So that's my phone number. You can call in. We still got some time left of my live stream. It's about 9 more minutes before we will have to close down. But that is my number there. And Christina Reynoso from Texas is smiling, which is good. I think I had a question for her. Let me go up here. My question was, what was Christine Reynoso asking? Yeah, I've already told her that she will go. Jessica will go and try to get a hold of Mr. Davis at 6:30 on his show. And I thank you, Brown Recluse. That is from Lexington, Kentucky. I appreciate that. Dorothy Cook from North Carolina, and Christina Reynoso from Texas. And Tentative, I have no idea where you're from. You got your first name, but I need your city or county and your state. And if you're outside of the state, I need your country. And this latest one, who's the Facebook one, says, thanks to be God. Okay, I'm glad to meet you there, but I need a really name, and should be a question about CPS. Now, Dorothy says that page is hers. Now, I don't know what page you're talking about. Thanks to God for each and every blessing from North Carolina. Okay. I guess, I don't know if you have another name. Is that what you have, two names there? I'm totally confused. As far as being video recorded, it really can't. You can ask, but they don't want to because they will incriminate themselves. They can have a detention hearing if the parent's not present. If the parent is locked up, or inaccessible, but they're supposed to have the parents there for the detention, because the detention hearing is where the child's going to be placed if it's necessary. Because the child going to be placed at the parent's home? Is it going to be taken in? Is it going to stay with a kinship, a family member, or is it going to go to foster care? And sometimes they railroad things right away. Now, Dorothy says that my case was legal from the start. I was given notice of the dependence hearing after the hearing was done. Yeah, it is. Your violation of your constitutional civil rights are there. You have a perfect lawsuit against the entity in Texas that did that hearing. If there's something, if you were arrested and locked up in jail, of course you won't be there. But the parents are supposed to be at the detention hearing. That's really important. That's really, really important. There's supposed to be a family team meeting where they have the kids, the parents, the facilitator, and the social worker, and some other pertinent people in attendance to make decisions about the child. They're railroading everything else. You're going to find CPS is corrupt, and they're very corrupt in Los Angeles County. They're very corrupt in Orange County. They're very corrupt in San Bernardino and Riverside. They're also corrupt in Kern. A lot of the agencies across the country are corrupt. Their main thrust is to make money. They lie. They will retaliate. They'll do everything to destroy your family. They tried to destroy me. For 5 years, they harassed me for 5 years. And like a fool, I believed in them. I believed in the government, so I allowed them again to see my home. And all the other times, nothing wrong with my home. But because I took my family's belongings, these were for my mom and dad. My dad had died. My mom was living. I had brought them home to sort and give them to family and friends and so forth, relatives. I did not have the money to put them in a storage room or have the money to continue to pay my dad and mom's home. And my sister wanted to sell it. She wanted to do a quick sell of the home. And the day she sold the home, the home made almost $300,000 they lost. I hate this when people try to rush things. They really do. I lost half the value of my home doing a quick sale because I need the money fast to hire Mr. Davis. And I'm glad he did. He got back my 2 boys. But anyway, I've now talked a good hour. And I have, it's now almost 8 o'clock. 3 more minutes. I got 3 more minutes before it's 8 o'clock. So again, it's getting too late for anybody to call. You can call me at that number if you want to hire Mr. Davis, and you can talk to me from 8 in the morning to 10 o'clock in the morning Pacific Standard Time, and that's Monday through Friday, or from 11 o'clock Pacific Standard Time to 1 o'clock p.m. Pacific Standard Time. And I will talk to you about hiring Mr. Davis and sending out an agreement to sign an agreement and to pay the retainer. Yes, I know the retainer, like in LA County, it's $5,000 as a retainer. Now, just the other day, I quoted Georgia, Atlanta, Georgia, a couple there, and it was $125,000. Now, that includes the per diem, the airfare, the ground transportation, the hotel accommodations, and the food. It also includes the cost of the license to practice law in Georgia. There are additional expenses that will occur. In order to practice law in every state, you have to be licensed. And you can get multiple states with multiple licenses, but you got to pay. And it isn't worth attorneys to have all 50 licenses current because they'd have to pay 50 states times the fee of a license. If the license are, let's say, $1,000, that's $50,000 a year, and they may only go to 2 or 3 states. So that's why they don't have license in every state. And it's simple to get a license. It's really simple. Now, I have my rules. Don't forget my rules. There are 5 of them. 1, get a real attorney. Get a real attorney. Don't depend on the court-appointed attorney. Tonight, we found out that an attorney that's representing a couple in the LA County has 100 cases. 100 cases she's handling. That's ridiculous. No one in their right mind can fight 100 cases. So get a real independent court attorney. Get a real attorney that is schooled and educated and licensed in juvenile law, family law, and dependency law, and that has fought CPS and won money back from fighting them. It's very important, those 2 things. Have won lawsuits against CPS and have gotten back children. That's the kind of attorney you want, a fighter. And I have one. His name is Vincent Davis. And there's a picture of him on the top right. And he's on at 6:30 in the morning for questions and answers. Now, rule number 2 is documentation. Make sure you have a notebook. Collect all your documentation. Use table of contents, tabs to designate where things are at. A very important document to create is called the incident time log. The incident time log is every incident you have with the social workers, with the CPS, with the police, with the school, with other parents, with whatever you have an incident relating to your CPS case, you devote 3 lines on a piece of paper. Skip a couple spaces to the next incident. Skip a couple spaces. The first line is the location where the incident occurred. If it was on the phone, you put in the phone number. Then you put the date and the time it took place and the people that are involved. That goes all in the first line. The second line is a summary of what the incident was all about, a short summary. And the third line is the outcome of the incident. If you don't have the outcome, it may take you weeks or months. You come back later and fill it out. But that incident time log will save you It's one that will be good 6 months from now, a year from now, because as a minimum, most cases you're going to be involved at least a year. Reason being is a couple of the things you have to take, like drug rehab, is 12 months program. Domestic violence is 12 months program. So if you're found guilty of either one of those things, you're going to have to at least be there for a year, and you're going to have a hard time remembering. So that's the documentation. The next thing you're going to do is you're never going to open your door to social workers or police. You never know who's going to be at the door. They'll shoot you first and ask questions later. Too many people, innocent people, have been killed opening the door because of mistaken location and an overzealous police officer shooting out his whole gun 5 times, point blank. The person is dying on the phone, to his fiance. It's terrible what they've done. So if you don't answer the door, that's fine. You can look at it later and see what was left there. If you have video cameras, you record it all, and you can get back to them. But you must have an attorney representing you. You must talk to an attorney first before you talk to them. And if you're going to talk to them, have the attorney with you. And I know it's a lot of money, and a lot of you don't have legal insurance, but you should think about it. You can get legal insurance, by the way, that will cover your attorneys in legal matters. And watch the traffic, watch the medical traffic, because social workers are hanging out at urgent care and they're hanging out at the emergency rooms. And they'll turn things around, just like this couple did, and make false allegations. Also, if you're having a child, don't let them take your child. Even have a police officer, tell them to get them out of the room. They can't take your child. The only way they can talk to you is they have to have a warrant that specifically tells them they can. And it's got to be a real warrant, one that has a wet signature with the clerk's seal stamped on it, so you feel the bumps on it so you know it's real. It's got to be specific directions. It's got to be on a date that they would have got it on, because if it's on the weekend or a holiday during the midweek, it's not a legitimate warrant. They will use old warrants. They'll document up. And it's got to be on a regular legal size paper, not a PDF file or any kind of thing like that, because they'll document the documents. CPS is notorious for lying. They're lying. And then don't forget the internet. You need to research it correctly. All you do is you put in the city and the state and the letter CPS. If you're from another country, put the country in. Then ask the question. Ask the question to specify what you want to find in CPS matters. And spend 60, 80 hours. There's so much information on the internet. And lastly, make a copy of all your important documents. Put them in an envelope. Your driver's license, your birth certificate, your children's birth certificates, your marriage certificates, your children's grade reports, your children's shot records, your marriage license, all the important documents. Make copies, stick in an envelope, and then put it with your documents. You'll need that. And those are 5 simple rules that I wish I had done. I wish I had done those 5 rules. They would have really helped me, and I would never have lost my children. I never would have. Especially getting an attorney. Just make those phone calls. Get 3 quoted attorneys. I'm giving you one right now, Vincent Davis. I already told him how much he's a $500 attorney. He's already trained in CPS. He has fought CPS for 39 years. He was once a foster care child himself, so he knows about foster care. And he's licensed in juvenile law, family law, and dependency law. And he's a real fighter. He's fought against CPS and won millions of dollars, both in state and federal court. Also, you should think about asking for a jury trial. That's something that's come across me. A couple of people said, well, why can't we have a jury trial? Because if you're judged by your peers, you're better off, because the judges are corrupt. The attorneys for the CPS are corrupt. CPS is corrupt. It's a kangaroo court. And I've been told, I'm still working on it, that you can ask for a jury trial. You can ask for a jury trial. Because your peers are more qualified than a social worker or attorney that works for a social worker to make a determination about you. Have your kids be careful what they say. I don't mean lie, but have your kids very carefully. Don't divulge information. And if they want to talk to your children, tell them they have to talk to my mom and dad. And then mom and dad, you tell them that we need to have an attorney present. There's so many things you can do to stop the harassment and the things that happen to you. And I'm sorry, you just realized, Dorothy Cook, that your case was illegal from the start. And most of you, when you hear about CPS, you don't know who they are. You do not know who they are. And I'm telling you, they're not your friends. That doesn't mean every CPS is bad. There's more good ones than bad ones. But over the cases of 4.2 million people that were alleged did something to the child abuse or neglect, and they were called in by mandated reporters. These are the official reporters like firemen, policemen, doctors, teachers. They called it in, and of the 4.2 million, 2 million were false. It never happened, so they weren't investigated further. So 50% of cases called in are at faults. And on top of that, 75% are for neglect and 25% are for abuse. And all social workers doing is putting the fear into you all about this. They're putting the fear factor because you're poverty or you're homeless or whatever it is. That should not be a grounds for neglect or abuse. It should not be a grounds for it. It's been proven that the best parents are the biological parents. It's been proven that the kids need to be reunified with the parents. That is the goal. That should be the goal. And I don't care about the laws or change or sign that CPS is going to get additional $35,000 if they have adopted in foster care. That was a sham that was passed in 97 during Bill Clinton's administration. You know, it's really funny what people say they do to help out victims of CPS. All I can say is that I really care about you guys. I'm on here twice a day. I'll be here again tomorrow morning at 10 o'clock, and I'll help you any way I can. I'll try to investigate and determine an answer and try to show you down the path. Now, the best person, again, is that professional attorney. It's that professional attorney. So with that being said, there'll be a brief video following my live stream when it ends. It's from Mr. Davis. It's a good video. I think you'll get a lot of message from it. Again, thank you, Dorothy Cook, from talking to me tonight from North Carolina. Thank you, Christina Reynoso from Fort Worth, Texas, I think it is. Thank you for calling in. Thanks be God. I have no idea where you're from, but thank you. Thank you, Intended Eve. Again, I don't know where you're from. I've already talked about. Brown Recluse is from Kentucky, Lexington, Kentucky. Thank you for being in here. And again, God bless you all. Keep fighting for your kids. And this is Bob Pace.
A vivid picture is encrypted in your mind as the critics get in line like they're witnessing a crime. But then you notice there's a shiver in your spine from the feelings of discontentment and bitterness combined. Heartbroken when you listen to the judges, another kid's innocence corrupted, and if you go against then it's destructive. Consider this predicament the toughest, but we believe in a system fit for justice. Child Protective Services only pretends to save it. The one solution for this is worthy of instant praises. 30 years of experience with relentless cases. Allow me to introduce him. This is Vincent Davis, defending you when they don't think a mother fits the role. Is it juvenile dependency or government control? Observe the pain in their eyes. It's time for us to realize we are the last ones left. Put your faith in them.